Hello friends, we shall today take a brief look at section 65B of Indian Evidence Act from a techno-legal perspective. This section has been in the Indian statute since 17th October 2000, but still there are always certain doubts about how this section has to be applied for admissibility of electronic evidence in a court of law. The difficulties in understanding the section 65B has stemmed basically from the inability of some people to look at the electronic evidence with a techno-legal perspective. And we should try to bridge that gap during this brief session. We are today looking at the admissibility of electronic evidence, which is a concept which is slightly different from the genuinity of an electronic document. In fact, in the P.V. Anwar versus P.K. Bashir case, the Supreme Court did make a mention that genuineness, veracity, or reliability of evidence is seen by the court only after the stage of relevancy and admissibility. And section 65B is relevant for admissibility. And this includes legal recognition of electronic documents, legal recognition of electronic document as evidence, and a certain procedure for admission as set out in the law. Genuinity is a different stage in the appreciation of evidence by the court. And when a document or electronic evidence is admitted and its genuinity is challenged, then the challenger has to produce justification for the satisfaction of the court that his challenge should be sustained. The court, if required, can call the assistance of section 79A expert, that is section 79A of Information Technology Act, which is the accredited digital evidence examiner. So at the time of admissibility, the genuinity is not the criteria to be looked at, and we are not looking at section 79A certified digital evidence examiner to be present before the court of law. But prior to looking at section 65B, we need to look at some of the earlier sections, which are section 3, section 17, section 59 of Indian Evidence Act, as well as section 65A and 22A of the Indian Evidence Act. Then only the meaning of section 65B and the 5 subsections of section 65B will become clear to us. Now, section 3 says evidence means and includes electronic records produced for the inspection of the court. So this brings the basic admissibility of an electronic document as an evidence object. But the word electronic record used here has to be interpreted from the Information Technology Act, and it is a document which can be interpreted as a binary expression. And this binary expression can be seen as a text, it can be seen as an audio or a video, but it is always present in binary form. Now, when we come to section 17, it talks about the admission of a statement, and it says admission is a statement which can be oral or documentary or contained in electronic form, which essentially means that the law, which is the Indian Evidence Act, recognizes 3 types of admission statements, and one of which is the electronic form or the electronic document. The other 2 are the oral evidence and the documentary evidence other than the electronic record. Now, under section 59 all facts except the contents of documents or electronic records may be proved by oral evidence. So this eliminates the oral evidence for proving electronic documents. Then section 22A also in a way provides a clarification that oral admissions as to the contents of electronic records are also not relevant from the point of view of evidence. So electronic documents cannot be proved by oral evidence, and any oral admission of an electronic document is also not relevant. So electronic documents have to be admitted by some other means. That is the indication of section 59 and section 22A. Subsequent to this, there are sections 61, 62, 63, 64, all of which refer to the documentary statements other than the electronic documents. And section 65A clearly says that there is a special provision regarding evidence relating to electronic record, and that is set out in section 65B. So section 65A on the one hand says that the immediate previous sections which are applicable for primary and secondary documents, which are referring to documents other than the electronic documents, they are not relevant for electronic documents, and therefore we have to look at electronic documents only from the perspective of section 65B. So out of the three types of statements, oral, documentary and electronic documents, oral has been eliminated, documentary has already been considered under section 61, 62, 63, 64, and it is not applicable to the electronic documents as per section 65A. Therefore, now we move on to section 65B. Why this kind of segregation of electronic documents has been done from other physical paper documents can be understood if we look at the nature of an electronic document. An electronic document is a binary expression. A human who could be a judge cannot make any understanding of this binary document. Therefore, he needs some way by which he can understand these binary expressions. Of course, the computer hardware and software will help him. And when this binary expression is looked through a computer, then we have a means of reading it like a text, or hearing it like an audio, or even seeing it like a video. In future, we will have computers which will be able to translate the sense of touch and sense of smell. Also, if we have an appropriate hardware device, so that we can put our hands through a gloves or something like that, then we may be able to experience the sense of touch through the gloves or something like that. These are under development, and it is definitely coming up as part of the futuristic computer devices. However, when you look at an electronic document through a computer, hardware and software, it doesn't mean that we will always get one consistent rendition of the electronic documents. For example, the above electronic form, which is zeros and ones which are given there, can be rendered by one computer as a word Tirupati. In another instance, a computer can render it as a number, maybe some 6 zillion number or something like that. Then in yet another rendition, it may give you some unintelligible pictures, letters, whatever you want to call them. So only a person who knows English will read the words Tirupati as Tirupati. A person who knows Chinese may try to read it in his own way. So the same computer can dish out different renditions from the same source document. Therefore, if we as a judicial authority want to take this binary document as evidence, we must remember that there is no single interpretation of this binary document, but actually multiple renditions or interpretations are feasible, and each of these renditions are perfectly logical and sustainable in a court of law through an affidavit. Therefore, we come back to the situation where an electronic document, we do not know how to interpret it as an evidence. So this dilemma continues even when we use a computer to translate the binary document into a human experienceable document. So an electronic document is always a binary impression. It is created on a media used by the originating computer device. It is never the words or sound or picture which a human being can experience, which are all interpretations of the binary impression with the use of software and hardware as a person who is looking at it. A person who knows Chinese will look at it if there is a Chinese rendition. Otherwise, for you and me, it may look like some unintelligible text. So it depends both on the hardware, software, as well as the prior knowledge of the person who is observing the electronic document. So what we call as evidence is dependent on the electronic device and dependent on the knowledge of the beholder. That is why we say data is created by a computer but interpreted by a human being. Even when the judge has access to an electronic document and he himself opens the document in his computer, he will see either Tirupati or the Chinese words or the number, depending upon what software or fonts he uses. Then the question is, will he take the responsibility for the tools through which he sees the evidence, and then come to a decision that this is only this number, nothing else, or this is only Tirupati, nothing else. In which case, the judge becomes a witness himself and he has to interpret the binary document in whatever fashion he seems to agree with. Therefore, the judge will be under a dilemma of how to accept a binary document as a acceptable evidence. This is solved by the Indian Evidence Act through Section 65B, and that is why this is a great section to be there in our law, and under no circumstances should any court think of making any modifications to this Section 65B as it exists today. Now, Section 65B has 5 subsections, in which the very first subsection introduces a term called computer output as a reflection of the electronic record, and it declares that it can be produced without the production of the original, and it will be admissible as also a document. Subsection 2 prescribes some conditions for rendering this computer output. Subsection 3 recognizes the use of multiple computers. Subsection 4 prescribes the requirements of a certificate which the person who is viewing that electronic document and converting it into a computer output has to give. And subsection 5 recognizes that sometimes computers may be automatically programmed to do things, and that will also be part of an acceptable way of rendering the computer output. So this entire section 65B refers to the production of the computer output, not the original binary expression that is unpresentable as a original evidence. So this computer output alone is admissible as a document without the production of the original if the conditions contained in section 65B is satisfied. Now, interpretation of which computer is to be used for certification, who is the lawful owner, what is the period under which the document has been produced, which are all things which are referred to under section 65B subsections. They all relate to the production of the computer output, and it should not be interpreted as referring to the original binary document which was created by the originating device. Because of this, there is no need for us to classify electronic documents as primary or secondary, because the primary document is always the original binary impression, which is not human readable. It is readable only with the use of intermediary devices, and hence this original not humanly readable binary expression cannot be considered as relevant in the context of an evidence. We must also remember that while the original electronic documents emanates in one particular device, origination of the electronic document, it is stored in a device and then it is observed by a certifier. Certifier converts it into a computer output, and computer output is certified and produced to the court. Therefore, the originator is not the certifier. The device in which original creation took place is not necessarily the device from which the computer output is produced. And if there are transfers of the document to multiple computers in between, then contemporaneous certifications are required for each stage of the electronic document. I would request all experts to read section 65B with this perspective. This is only the practical and possible way of interpreting section 65B. Any other interpretations will render admissibility of electronic document as evidence an impossibility. Thank you.